Good morning, everyone, and welcome to today's webinar, Business Judgment in Unprecedented Times. Before we get started, I'd like to go over a few items so that you know how to participate in today's events, but also I'd like to firstly acknowledge the Gadigal people of the Eora Nation, the traditional custodians of this land, and pay my respects to the elders past, present, and emerging. Well, welcome. My name's Norman Donato. I'm a partner here at Bardia Perry in the Corporate Commercial Group. Karen is a co-presenter with me. She's one of the senior associates in our group as well, and we're delighted that you've had this opportunity to join us. It's been a very difficult year, and I hope everyone has gotten through it reasonably well, and only a few more weeks to go before Christmas. We thought it'd be worthwhile at this point to talk about business judgments in these difficult times, because we know that directors and officers of company are under a lot of pressure to make the right decisions, and it's certainly difficult to have a lot of clarity over the events that are unfolding. But before I get into the formal introduction, perhaps I'll take this opportunity to let you know that in today's event, there'll be an opportunity for you to participate. You're able to submit questions in the chat box, and if we have time at the end of this seminar, we'll try and get to your questions and have a bit of a discussion. We'll also have a bit of a poll at one point to get people's views on certain questions and to have a bit of participation as best as we can in this webinar event, this virtual sort of seminar. So without any further ado, I probably should get started. As I said, you know, it is quite uncertain times that we're in, and I think it's useful to review certain fundamental duties and responsibility of directors at this time. Amongst having to deal with the usual business challenges of running a corporation, such as the ever-increasing pace of technological change, changing community standards in the way we deal with the environment, employees, directors now have had to further reconsider their business models and commercial objectives. The recent pandemic crisis that we've faced have forced change on society and the business community. Whilst some commentators may have foreseen the possibility of a global pandemic, few, I think, really thought that it would hit us and hit us as hard as it has all around the world. So in this current climate, perhaps more than ever, directors are forced to take risks and overcome the fear of personal liability. And the law has to balance the value of entrepreneurial risk-taking with the need for appropriate standards of corporate governance and stewardship. So whilst there are numerous duties on directors, and Karen will go over some of those later in a bit more detail, the one we want to concentrate on today is Section 100 of the Corporations Act. It's the one that reminds us that the law imposes on officers of companies a professional standard of care when they're exercising their powers and discharging their duties. Just briefly, I think it's worthwhile just to read over what Section 180 subparagraph 1 states. It states, a director or other officer of a corporation must exercise their powers and discharge their duties with a degree of care and diligence that a reasonable person would exercise if they were a director or officer of the corporation in the corporation's circumstances and occupied the office held by and had the same responsibilities within the corporation as the director or officer does. I hate to remind everyone, but it's always important to understand that from a practical point of view, a contravention of Section 180 could result in penalties of up to $200,000. And if the corporation suffers damage, the court has the power to make an order for the director or officer to pay the company compensation. So as I mentioned earlier, Karen will briefly touch on the other responsibilities and duties imposed under the Corporations Act, and of course we're concentrating today on the statutory duties. There's also common law duties, contractual duties, tortious duties that arise. But given the nature of the business judgment rule, which is what we want to discuss, we think that it's important to focus on what protection that gives the directors, particularly in making some of the difficult decisions they're making at the moment. So what we'll do is we'll look at the elements that relate to the statutory duty of imposing an obligation to act with care and diligence, in other words, not negligently. And it's important to note that I mentioned earlier we've got statutory duties, we also got common law duties. There's a section in the Corporations Act that discusses how they interact with each other. The section is 185, and it states that the above mentioned duties imposed by the Corporations Act are in addition to and not in derogation of any rule of law relating to the duty or liability of a person because of their office or employment in relation to a corporation, and do not prevent the commencement of civil proceedings for a breach of such duty or in respect of such liability. Now, whilst that shows that the obligations are cumulative, the interesting thing is that against that backdrop, the business judgment rule stands as a defence to a breach of the statutory duty of care under section 180, subparagraph 1, and also a defence to its equivalent obligations at common law and in equity. So it's important to note that it will give you protection of your duties, not just in relation to statutory breach, but also your common law duties and duties in equity. So today we'll look at the business judgment rule, its benefits, its requirements, its limitations, because it's important to remind ourselves that whilst there is a need to make some difficult decisions, they do need to be made, but there are certain protections under the law, and it's important that we understand the scope of those protections. So what we'll do, I might start perhaps by introducing to you a problem. And what we'll do is, at the end of reviewing the legal principles and some of the leading cases, we'll come back to this problem and we'll have a bit of a discussion, and we'll try to apply some of these principles to working out, whether or not the director in this circumstance breached her duty of care and diligence in operating the company. And the scenario we've picked is fairly basic, but I think it's a good example of some of the challenges that are facing people or have been facing officers of company at the moment. And just briefly, as you can see there on the slide, there's some basic facts. A company has 200 employees, operates in Australia and Hong Kong. It has approximately 50 staff in Hong Kong. As a result of the pandemic, there's been a decrease in work of about 20,000 across the board. The directors need to decide whether to cut costs and retrench staff. Karen, a director of the company, and Karen didn't mind me using her name, does not want the company to retrench any staff. Stephen, the CFO, advises her, however, that if a vaccine is not found within 6 months and the company does not take steps to cut costs within that period, the company could find itself in a diabolical financial position. Karen is concerned that Stephen is being overly conservative and is not taking into account the value of the goodwill the company has and may lose if it retrenches employees, and the impact on customers if it doesn't act in what's considered to be a socially responsible manner. She strongly feels that it will damage the company if it is seen to be disloyal to its employees at this time of crisis. So Karen decides to ignore Stephen's advice and decides that she will not retrench any staff or make any cost-cutting steps. 6 months later, no effective vaccine has been found. A third wave of infections has hit the markets in which the company operates, and sales drop further, such that the company now has no alternative but to go into liquidation. The shareholders are ropeable that Karen ignored the advice of the CFO and claimed that by doing so, she acted irrationally, emotionally, and caused the company to collapse which could have been avoided had she taken the CFO's advice. They bring an action against Karen saying that she did not exercise her powers and discharge her duties as a director of the company with due care and diligence. So as I said, we'll come back to this example, to this problem later, and we'll have a bit of a chat and poll. We'll put some questions out there to see what people's views are and try to apply some of these principles and see what the relevant considerations are in understanding the potential liability or defence for the director in making the decision that she did. So we'll then wrap up the webinar and give people an opportunity to ask any questions. But anyway, for the moment, I think what I'll do is hand over Karen, and she'll shed a bit of light on some of the other duties that directors are under, and also talk about and introduce us to the business judgment rule. Karen, over to you.
Thanks, Norman, and good morning, everyone. Thank you for joining us. So I'll be taking us through the key legal principles before we have a look at some of the key cases in this area. And as Norman mentioned, we'll then revisit the practical example that we've just presented to you for some further discussion. So under the Corporations Act, the directors are responsible for managing the company. In the course of that management, directors have certain duties that they must comply with. Now, whilst there are various duties imposed under the Act on directors, the key duties are really found in sections 180 to 184 of the Corporations Act. And just in brief, those duties require directors and officers to exercise due care and diligence in the performance of their duties, exercise their powers and discharge their duties in good faith in the best interest of the company and for a proper purpose, not to improperly use information or their position to gain an advantage for themselves or to cause detriment to the company. Interestingly, under section 184, directors or other officers of the company will commit an offence if they are reckless or dishonest and fail to exercise their powers and discharge their duties in good faith in the best interest of the company or for a proper purpose. There is also an important duty under section 588G of the Act, and that is the duty to ensure that the company does not trade whilst it's insolvent. Okay, so looking now at the duty in section 180 in a little bit more detail. And again, this is the primary statutory duty that we'll be focusing on for today's presentation. Now, as Norman did note earlier, section 180 of the Act essentially imposes a professional standard of care on directors in the exercise of their powers and the discharge of their duties. The duty requires that directors or other officers exercise their powers and discharge their duties with the degree of care and diligence that a reasonable person would exercise in their position. Now, section 180 does make a reference to directors and other officers, and that reference also appears in sections 181 to 184 of the Act as well. So it is important to keep in mind that although we'll be referring generally to directors' duties throughout this presentation, the application of the statutory duties in sections 180 to 184 of the Act capture not only directors, and these are persons that are appointed to the office of a director, but also apply to officers of the company. So that brings us to the question of, well, who is an officer of the company? The Corporations Act does tell us who will be an officer of the company in addition to an appointed director. Now, the persons will include the company's secretary. It will include shadow and de facto directors. So these are people who aren't formally appointed as a director, but they perform the same function and role as that of an appointed director. It includes persons who are involved in making decisions that can affect the whole or a substantial part of the company's business. So for example, here we're looking at people such as the CEO and COO of the company. It includes persons who have the capacity to significantly affect the company's financial standing. So here we're looking at persons such as the CFO of the company. It includes persons whose instructions or wishes the board are accustomed to following. So for example, a major shareholder. It also includes receivers and managers, administrators, an administrator of a deed of company arrangement, a liquidator, and also a trustee or other person administering a compromise or arrangement made between the company and someone else. Now, that list is fairly extensive, and it demonstrates just how broad the concept of an officer is under the Act. Again, it's important to keep in mind that the application of the duties in section 180 to 184 are not confined to directors, but also apply more broadly to that category of officers that I've just taken you through. When we are looking at whether or not a director has complied with their statutory duty under section 180, their actions are assessed against the reasonable person standard. This test is an objective test, and what this means is we are looking at what a reasonable person, as a director of the company, in the company's circumstances, and with the same responsibilities as the director in question would have done. Now, when we look at what compliance means in practice, as I've noted earlier, and as Norman also noted earlier, section 180 imposes a professional standard of care on directors. So in practical terms, there's a minimum standard of diligence that is expected of directors and officers. And that means that there is an expectation that they are familiar with the fundamentals of the business, they keep themselves informed about the company's activities, they monitor in a general sense the company's affairs, they maintain familiarity with the company's financial affairs and position, and this would include reviewing the company's financial statements and board papers, and to make further inquiries into matters reviewed by those documents where appropriate, and to also have a reasonably informed opinion about the company's financial capacity. When a court is looking at whether a director has discharged their duty to exercise reasonable care and diligence under section 180, that assessment is made with regards to a company in the corporation's circumstances. And what this means is the court is going to be looking at factors such as the size and type of the company, the nature of the company's business, the composition of the board of directors, the particular director's position and responsibilities, that director's experience and skills, the terms and conditions, if any, that attach to their appointment as a director. So, for example, were they appointed for their expertise in a particular area? The court will also consider how responsibility for the company's business has been distributed between the board and other officers. What are the informational flows and systems in place? What do the reporting systems in the company look like, together with any other relevant acts, omissions and circumstances in the given case. So that's section 180, and what I will now do is just briefly introduce the business judgment rule before Norman looks at the issues in a bit more depth. So the business judgment rule is used as a defence to meet a claim that a director has not discharged their duties with the requisite degree of care and diligence expected. The policy underlying the business judgment rule is that we need to recognise the need for directors to engage in considered risk-taking and to protect those directors when those risks are part of an informed business judgment. There is a recognition that directors are generally better suited than courts are to make a business decisions, such that the business judgment rule then operates to protect directors from liability when they've made an honest mistake of judgment, or even when they've made a business decision that is unpopular. Now, at common law, there was a form of the business judgment rule that existed prior to the enactment of the statutory business judgment rule. I'd like to point out here that the statutory rule does replicate in a lot of elements the form of the judgment rule at common law. Now, the formulation of the business judgment rule does attempt to strike a balance between ensuring that directors are not constantly questioned about their business decisions, but also ensuring that directors are held accountable for their actions. The courts in general are reluctant to review bona fide business decisions, and we've provided for you here an extract from the case of Harlow's Nominees, which is a 1968 decision that confirms the reluctance of the courts to really interfere in what they consider to be business decisions. Now, the court in Harlow's Nominees did make a reference that, or they noted that the judgment cannot be exercised for irrelevant or improper purposes. And what this requires is that the directors aren't pursuing purposes which would advance personal benefits for themselves rather than for purposes associated with the benefit of the company. Okay, so I will now hand you back to Norman, who is going to take you through the business judgment rule in a little bit more depth before I then take you through some of the key cases in this area. Thank you, Norman.
Thanks, Karen. As Karen said, there's a lot of policy reasons why the rule was introduced, and that was to try and give a bit more clarity and a bit more certainty for directors who are concerned about personal liability in certain decision makings, and it was there to encourage entrepreneurial flair. So what I'm going to do now is go through each of the elements in a little bit more detail and mention a number of cases where the rule has been considered, although there hasn't been as many cases as perhaps people would expect. But on the one hand, that might be a good thing because it may be having the impact that that it was intended, and that is to minimise the need for directors to call upon it when being challenged about decisions. And after I go through each of the elements, Karen will come back and discuss a couple of the major cases that probably we've all heard, the Untitled case with the rich and the HIH case. And so it'll be interesting to get a bit more understanding of particular facts in those cases, particularly when we come back at the end and start looking at trying to resolve that problem that we posed at the beginning. So what does section 180 subsection 2 actually say? And it's worthwhile to walk through it because you can see when you walk through it some of the key features of it and how it's been designed to try and give a bit of clarity of what is required in order for officers of a company to rely on this defence if they've been accused of breaching their duty of care and diligence. So the section says a director of a corporation who makes a business judgment is taken to meet the requirements of meeting its duty of due care and diligence under subsection 1, and the equivalent duties at common law and in equity, which is important. It's a defence for any similar claim in respect of the judgment if they A, make the judgment in good faith for a proper purpose, do not have a material personal interest in the subject matter of the judgment, inform themselves about the subject matter of the judgment to the extent they reasonably believed to be appropriate, and rationally believe that the judgment is in the best interest of the corporation. Now, importantly, the director's belief that the judgment is in the best interest of the corporation is a rational one unless the belief is one that no reasonable person in their position would hold. Now, the cases that I'm going to talk about sort of expand on what those requirements actually are, but you can probably get a feel for them already. But importantly, we should firstly consider what is a business judgment, and the legislation actually goes in and discusses that. It tries to define it, and it says a business judgment means any decision to take or not take action in respect of the matter relevant to the business operations of the corporation. The director's belief that the judgment is in the best interest of the corporation is a rational one unless the belief is one that no reasonable person in their position would hold. And the section then goes on to note that the section only operates in relation to the duties under this section and their equivalent duties at common law and in equity. It does not operate in relation to duties under other provisions of the Act or under any other laws. So that is a key limitation of this. It's only a defence for a breach of the duty to act with care and diligence. So as Karen mentioned, prior prior to coming back to me. There is at common law, a general law, a business judgment rule, and I won't go over that. She's already done that. But what is important is that in the Harlow case, the High Court said that the general law business judgment rule was developed to give directors a greater degree of certainty when making decisions and to promote entrepreneurial risk-taking, as noted by the commentators. However, another reason for its development may be that the courts are simply ill-equipped to review genuine matters of common law judgment. This is demonstrated in cases involving applications for directions by insolvency practitioners who are officers of the companies they manage, where the courts have steadfastly refused to give directions on matters of genuine commercial judgment. While the court's focus may be drawn by the decisions tainted with an abuse of power and improper motive, the commercial merits of the decision are not reviewable by the courts. Now, I think that provides an important context to a lot of this and should give directors a great degree of comfort, because, as Karen mentioned, two of the essential elements of the common law duty, business judgment rule, are embodied in the statutory provision. And that is in paragraphs A and B of subparagraph 2, and that is that the judgment has to be made in good faith and for a proper purpose, and that the director does not have a material personal interest in the subject matter. The section goes on, however, to introduce other elements about the degree of information that's required and the rationality of the belief in the judgment being made, and expands upon that. But it's important to note that the courts are not equipped to make commercial judgments. They're reluctant to do so. So one can see, by contrasting the descriptions of the business judgment rule and the general law rule, the following distinguishing features of the statutory defence. It introduces a presumption in favour of director's judgment, because the director believes that the judgment is in the best interest of the corporation is a rational one, unless the belief is one that no reasonable person in the director's position would hold. So that's an important presumption in favour of the director. It allows directors also some comfort in making decisions based on information reasonably available to them at the time, provided they were made in good faith and the director rationally believed it was in the interest of the company to make the decision. So let's drill down into some of the elements and look at each of the paragraphs. Now, it may seem obvious, but obviously, in order to derive the benefit of the defence, there first must be a business judgment. And as obvious it may seem, not everything is a business judgment. So the elements of a business judgment are explained in subsection 3 of paragraph 180 of the Corporations Act. And it involves the making of a decision and in respect of a matter relevant to the business operations. And so, as courts do, they expand on those things and highlight certain distinctions between, what is a decision and what's making a decision. And what the courts have found is that, first of all, the requirement is to actually make a decision. A director or an officer cannot avail himself of the business judgment defence simply by not turning his mind to a particular question. And the cases have noted that that where there has been a breach of a duty, in fact, one case involved a question of whether or not directors which had approved various loans could avail themselves of the business judgment rule, because they actually agreed to go ahead with certain loans, which in hindsight were probably not sensible to do. So in an action against these directors, the directors sought to rely on the defence and pleaded the defence. Interestingly enough, the case expanded upon the need to actually identify the various decisions made, and the pleading was struck down because the pleading was said not to actually show any particular decision was made. The pleading went along the lines of something like this: insofar as the relevant director was involved in formulating, monitoring, or implementing it. And I talk about a pleading, this is the defence that was pleaded. Insofar as the relevant director was involved in formulating, monitoring, or implementing the loan acceptance procedures or lending policies, and insofar as he engaged in conduct or made decisions with respect to the loans, the subject matter of these proceedings, the relevant director behaved as he did because he made business judgments that were made, and then the defence just referred to the elements of section 180 subparagraph 2. The court said it can be seen that the statutory business judgment rule applies if and only if the director makes a business judgment. A business judgment is defined to mean any decision to take or not take action in respect of a matter relevant to the business operations of the corporation. Thus, section 180 subparagraph 2 can be invoked only by a director who has made a decision. That would not apply to a director who did not turn his mind to a question. Where a director has made a decision that is a business judgment, then attention must be given to the requirements of the subparagraphs as they relate to that decision or decisions. So you've got to link the particular decisions and the criteria in section 180 together in order to be able to call upon the defence. So it's necessary. So then an analysis is requirement as to whether or not you satisfy those requirements under section 180 once you're able to identify the decision and the material facts upon which the director relied upon. Where a director cannot identify the material facts relied upon in asserting that the requirements of subsection 180 paragraph 2 have been satisfied, he cannot rely on the defence. A similar result was found in another case where a director failed to attend board meetings which were held where it was held that he took no interest in the affairs of the board, and therefore was said not to have made a business judgment which would fall within the scope of the defence. He just basically wasn't interested and didn't turn up, and the court said, well, you know, you did not turn your mind to the affairs of the company, therefore you're not in a position to make any defence. So business judgment therefore involves an actual decision, not a general neglect of duties. And this was explained in the Untitled litigation by Justice Austin, where he said, monitoring the company's affairs, maintaining familiarity with its financial position, and not in themselves matters that involve a decision to take or not take action in respect of the matter relevant to the company's business operations. So he's, as Karen alluded to earlier, just simply monitoring the affairs of the company is not making a decision. So failing to monitor the company's financial performance is not an action or inaction for which the directors are said to have made a decision and therefore made a business judgment, and therefore simply neglect of duties will not be sufficient to enable a director to say that they're entitled to make a business judgment. They've made a business judgment and are entitled to the defence. The other thing is that decisions have to be made in relation to business operations, and this is a limitation. One might think that any decision made by a director of a corporation, if that corporation operates a business, is a decision that is made in relation to business operations of the corporation and would fall potentially within the protection of the business judgment rule. That's not the case. For example, it's been held that a decision causing the publication of an ASX announcement was not a business judgment, as it did not relate to a matter pertaining to the business operations of the company. The court examined the requirements and said that, and it referred to another interesting case. This was a case called ASIC versus Vocation, and in that they referred to the judgment of the Chief Justice Keane in ASIC versus Fortescue Metals Group, where there there was again a misleading statement put out by the chairman, Mr. Forrest. And in that, the judge quoted the following passage with approval, said that Forrest bore the onus of proving that he made a judgment in good faith and for a proper purpose, and that his shareholding in FMG was not a material personal interest in the subject matter of that judgment. The absence of evidence from Forrest makes it difficult to see how Forrest could discharge that onus which he bore to establish these elements of his defence. This difficulty apart, the decision not to disclose the true effect of the agreements cannot be described as a business judgment at all. A decision not to make accurate disclosure of the terms of a major contract is not a decision related to the business operations of the corporation. Rather, it is a decision related to compliance with the requirements of the Act. And so what it shows is that there's a distinction between a decision dealing with the operations of the company and compliance obligations. And compliance obligations are not protected as a result of the business judgment rule. So a director cannot simply make a decision not to comply with a piece of legislation or an act and simply say that, well, that was a business decision, therefore you can't take action against me. Now, there has been some questioning of that and the extent of that, but I think it would be dangerous for any director to assume that they can make a decision and claim that it was protected by the legislation, by the business judgment rule. And the only case that I'm aware of that there seemed to be some protection of that, or the main case, was a case called Mariner. And there the judge seemed to say, and it wasn't necessarily, it's not necessarily a precedent, it was obiter dicta stated, that again, this weighing up of the risks and rewards that are required may, in certain circumstances, not so much avail the director to the benefit of the business judgment rule, but may result in objectively the director not breaching his duty. But again, I think personally it would be dangerous to go along the path of assuming that one can find protection under the business judgment rule for decisions to ignore compliance with any pieces of legislation. So the next one, and the next two sections I think are important, because the first two that we talked about, which deal with holding the, that the judgment was made in good faith and proper purpose, and that there was no material personal interest, pretty much reflect what the general law said, but the next two are slightly different. And so the next one talks about that the director has to inform themselves about the subject matter of the judgment to the extent they reasonably believe to be appropriate. Now, the statutory business judgment rule clarified the requirement that a director or officer must have been informed about the subject matter. In Rich's case, which Karen will talk about later and explain the facts further, ASIC claimed that the statutory business judgment rule introduced a reasonableness test because of the requirement. Justice Austin said the test under the subparagraph is not purely an objective test. His Honour said protection may be available even if the director was not aware of the available information to the decision, if he reasonably believed to have taken appropriate steps on the decision-making occasion to inform himself about it. Justice Austin also pointed out that the reasonableness of the level of information relied on is to be judged according to the importance of the decision, the business judgment to be made, the time available for getting the information, the costs related to obtaining the information, the director and officer's confidence in those exploring and examining the matter, the state of the company's business at the time and the nature of competing demands on the board's attention, and whether or not material information is reasonably available. In this context, the director must identify again the facts and matters upon which he or she base his belief on. So the importance of that is that what Justice Austin was trying to do is to say, well, there's no point simply saying that there's an objective test in applying this defence, because the distinction then between the defence and the actual obligation starts to become a bit blurred. And what he's done is actually lowered the bar in terms of reviewing the conduct and making it much more friendly for the director in saying, well, you know, in order to avail your defence, we have to look at the circumstances you were faced in when you made that decision, as opposed to necessarily having a purely objective test, which is really what the section 180 paragraph 1 says. And then this aspect of it is backed up by the next subsection of the defence, which says that the decision that the director must rationally believe that the judgment is in the best interest of the corporation. So these two introduce this position that you can avail yourself of the defence even if you made a decision not based on full information, and again making it more comfortable to make a decision rather than to be sort of procrastinate whilst and waste time or take up a lot of time trying to be absolutely certain that the decision you're going to make is not a breach of the duty. So this is a further element that must be established. Again, Austin, in Richard's case, shed light on the proper analysis of this element. His Honour stated, subparagraph D is satisfied if the evidence shows that the defendant believed that his or her judgment was in the best interest of the corporation, and that belief was supported by a reasoning process sufficient to warrant describing it as a reasonable belief, as defined, whether or not the reasoning process is objectively a convincing one. The director's or officer's belief about the best interest of the corporation is to be formed and its rationality assessed on the basis of the information obtained through compliance with subparagraph C. It is not to be assumed for the purpose of applying subparagraph D that the director or officer, that everything he or she ought to have known, only the things that he or she reasonably believed to be appropriate to find out. So it's important to remember that the focus is about the process. You know, was there a process implemented? It's not necessarily whether the decision was right or wrong, or you had all the information, but did you have a process that you could rationally say it was reasonable to make the decision that you made? And again, it's important to understand that the onus is on the director, apart from the presumption we discussed earlier, to establish that any decision made or decision not to do anything falls within the requirements of the business judgment rule. So I think what we'll do now is I'll hand back to Karen, who can probably explain some of the facts, particularly in the Rich case and the other leading case in more detail, which I think will then help us wrap it up and try to answer the final problem. Karen.
Thanks, Norman. So moving now on to some of the key cases where the courts have considered the business judgment rule and whether or not it was found to apply. The first one I want to take you through is the case of Asic and Rich. Now, this was a 2009 decision of the New South Wales Supreme Court. And this case arose out of the collapse of the Untitled Group in May of 2001, together with the collapse of its local subsidiaries and some overseas subsidiaries also of the group. At the time of its collapse, Untitled was the fourth largest telecommunications provider in Australia, with more than 2 million customers and operations in 8 countries. Despite rapid growth and the company being valued at $5.3 billion in 1999, the company reported significant losses in 2000. Untitled became insolvent in May of 2001 after major investors, being essentially the Packer and the Murdoch families, initially agreed to inject $132 million into the company, but then withdrew that support shortly thereafter, claiming that they had been misled about the company's financial troubles. So ASIC initially pursued proceedings against 4 directors, settled against 2, but then continued proceedings against 2 other directors, being Jody Rich and Mark Silberman. And ASIC's claims were that they had breached their statutory duty of care by failing to disclose or withholding information from OneTel's board about the company's true financial position. Now, the directors invoked the business judgment rule defence, and as part of their pleadings, they referred to matters relevant to OneTel's business operations in respect of which they had made a decision to either take or not take action. Those matters included what information in relation to OneTel's financial position and performance was material at any one point in time, what information in relation to OneTel's financial position and performance should be brought to the board's attention and in what manner, what systems were appropriate to be established and maintained for the provision of financial information to the board, what level of cash reserves of the OneTel group were appropriate at any particular point in time, and also whether there was a reasonable factual basis for public statements that had been made by OneTel. The court in this case agreed that the business judgment rule defence did apply, and in making that finding, the court held, among other things, that the directors had made business judgments because they had turned their minds to the relevant matters and consciously made a decision either to take or not take action in regards to each of those matters. The court found that the decisions were made in good faith. There was no suggestion in the pleadings that the directors had any material personal interest in relation to the matters in dispute. And the court also found that on the facts, the directors did rationally believe that their decisions were in OneTel's best interests and that that belief was supported by a reasoning process sufficient to justify their beliefs as rational. So moving on to the next case that I want to take you through, this is the case of ASIC and Adler, and this is a 2002 decision of the New South Wales Supreme Court. So this case again involved claims under section 180 subsection 1 against certain directors and officers, including the CEO of HIH, which at the time was one of the largest insurance companies in Australia prior to its collapse in 2001. Rodney Adler was a non-executive director of HIH, as well as a major shareholder. So in June of 2000, Mr. Adler requested, and one of the directors and the CEO of HIH arranged for a subsidiary of HIH to advance an unsecured and undocumented loan in the amount of $10 million to a newly formed company called Pacific Eagle Equity Pty Limited, which I'll refer to as PEE. Now, PEE was controlled by Mr. Adler. The loan was made without the knowledge of the other directors of HIH. The 10 million loan funds were used by PEE to purchase approximately $4 million worth of HIH shares on the stock market, to purchase $4 million worth of shares in unlisted technology and internet companies from a company called Adler Corporation, all of which were loss-making, and to also provide approximately $2 million worth of unsecured loans to companies that were associated with Mr. Adler. ASIC brought proceedings against Mr. Adler and the other parties involved in the transactions, and the allegations were that they had breached various provisions of the Corporations Act, including provisions relating to related party transactions, financial assistance, and also a breach of the statutory director's duties under the Corporations Act. Now, looking purely at the claims made under Section 180 against Mr. Adler, he attempted to invoke the business judgment rule to meet the claims against him that had been made under Section 180 subsection 1. And not surprisingly, given the facts of the case, the court determined that Mr. Adler had breached his duty under Section 180 and that the business judgment rule defence was not available to Mr. Adler in this case. In reaching that finding, the court held that a reasonably careful and diligent director would not have allowed the $10 million loan to be made in circumstances where part of those loaned funds would then be used to acquire shares in HIH. Mr. Adler clearly had a material personal interest in the loan transaction, and he had failed to act in good faith and for a proper purpose by obtaining an unsecured loan from the HIH subsidiary to purchase HIH shares on the stock market and also to acquire shares in unlisted companies which at the time were facing cash flow difficulties and at significant risk of collapse. Now, the other parties involved in the contraventions also attempted to invoke the business judgment rule defence, but the court also found against them on the basis that as they were aware of the $10 million loan and Mr. Adler's potential conflict of interest in the matters, they should have brought the issues to the board's attention. The court's view was that turning a blind eye or simply distancing themselves from the breach would not assist them in avoiding a claim under Section 180. Okay, so we have now gone through the key legal principles in regards to Section 180. Norman's explored in depth the business judgment rule defence and the various elements. So what we'd like to do now is take you back to that practical example that we raised with you at the start of this presentation and just see if we can workshop some of the issues involved in that. Norman? Norman, are you...
Sorry, I need to unmute myself. So we just might give everyone just a couple of minutes just to have a look at that, and then we'll have a couple of poll questions, and then we'll feedback the answers there, and we'll just discuss, you know, which of those elements of the business judgment rule that we talked about are the likely ones that are going to be a little bit more controversial in this problem, and what people's views are about those. So we might just give you a couple of minutes, and then we'll get our assistants to put up the poll questions. We might put those up now and have people do that as well, and then come back to it. Now, you know, part of I think the dilemma that officers face and advisors face is that whilst the law tries to be as clear as it can on these principles, it obviously, circumstances vary from company to company and situation to situation. So the law can't be as prescriptive as perhaps some people would want, and there has to be a reasonable degree of flexibility. Unfortunately, with that comes a bit of uncertainty and risk, but I think, you know, the position should be that the protections are not there to make people sort of run amok and do whatever they like, but they have a fair degree of support by the law and the flexibility built within that to get out there and take some risks, provided, I think, the bedrock of the protection at general law, which is also in the statutory provision, is not overlooked, and that is that you know, the question of not having material interests and making decisions in good faith and for a proper purpose. Now, sorry if I distracted you by reading that, but I was told that in a webinar it is not appropriate just to say nothing and let people read. I hope you've all had an opportunity to read over and answer the poll questions. So the poll questions, the first one is, did Karen breach her duty under Section 180 by ignoring the CFO's advice? And the other one, the other question is, you know, which of the following elements of the rule do you think Karen may not have satisfied? So I'll give you an opportunity. So Karen, you can jump in if you like at any stage if you want to highlight anything at this point.
Yeah,
when we were discussing, sorry.
I was just going to say, I think it's worth noting that obviously what we've presented to you in this example is a fairly, if you like, simple example. We've tried to keep the facts fairly scant, so there may be perhaps some information that you might need to answer the poll question that perhaps isn't there. And that's really the beauty of it, so that to try and encourage discussion around these issues, because a lot of the time the answer isn't clear cut and there's a lot of competing factors at play. So just keep in mind that you may not necessarily have all the information that you would like to have in this practical example.
All right, so I assume we'll get a result of the poll questions shortly. But in the meantime, why don't we start discussing some of the requirements? I suppose, Karen, you sort of alluded there to one aspect of the problem that that you might consider to be particularly interesting. Do you want to sort of elaborate? I'm sure we've got the answers in, and we're not giving anything away at this stage.
So again, the poll question that we have put to you is whether or not Karen breached her statutory duty under Section 180 by ignoring the CFO's advice. So again, just reminding you that what the duty requires is that she exercised her duties and powers in good faith and in the best interest of the company. Did she exercise care and skill in the performance of those duties? Has she got a conflict of interest perhaps? And then also, is there any suggestion that she might have misused her position improperly? So I have actually taken you through all the sections of all the key duties, as opposed to limiting that to 180. So let me reframe that. So has she satisfied her duty to exercise care and diligence? Okay, so that's the primary question. And what would a reasonable person perhaps have done in her same position? So if we can keep those questions in mind, that might help frame your answer. Do we know if we've got any answers yet on the first question on the poll?
Hi, Karen. I'll just let you know that 36% said yes and 64% said no.
Okay. Okay, so there's a clear leaning towards a non-breach of the statutory duty. So, Norman, based on the fact, yeah?
Yeah, well, that is interesting. I am a little bit surprised that, well, not surprised. It just shows how difficult it is. But obviously, the business judgment rule is there to encourage people to take a risk and to make an assessment and not to be conservative. And if you look at the problem and the question, the way that we've posed it, obviously, it's not a matter of just getting the right or wrong answer, or in retrospect, the cases have said, you've got to put yourself in the position of the director, not in retrospect, but when the decision was being made. And sure, the CFO's view on the financial affairs of the company are obviously very important, but does the CFO have necessarily any more expertise and knowledge as to how a crisis, a pandemic crisis will unfold? Does anyone significantly know that, unless you're, an expert in such pandemics? So, so I think, the fact that she didn't necessarily make her decision based on that advice is not necessarily sort of damning from her position or being able to rely on the defence of the business judgment rule. Now, if you then go back into the other elements, and I'm not sure if we've got the results of what people said, what the other elements were. We do. We said that. So 20% said that she may not have satisfied the requirement of acting in good faith for a proper purpose. That's interesting. No one said that she had a material interest, and I tend to agree. 70%, and might have been led a bit by Karen, were concerned that maybe she didn't inform herself properly on the subject matter, and 10% said that they're concerned that she didn't rationally hold that belief. Now, I tend to agree. I think the big thing here is, did she properly inform herself? And again, as we mentioned earlier, and Justice Austin explained, it's a question of the process that she went through. And as Karen said, we don't have a lot of information how she informed herself of what was likely to unfold. And I think it would have given us, in my view, a greater ability to predict with a bit more certainty the outcome of whether she was able to satisfy this judgment. If there's a bit more information about what other basis what other information she took into account in informing the view that she did. Karen, do you want to add anything at this point?
Yeah, I agree. And perhaps I was being a little bit leading, Norman, when I was doing the little disclaimer up the front. But you're right, we haven't got a lot of information. Really, all we do know is that Karen had a discussion of sorts with the CFO. The CFO suggested a particular course of action, and Karen chose not to follow that course of action. So again, that's really the only concrete facts that we've given you about the process of her decision making. But as Norma mentioned, we haven't included whether or not she had regard to other matters in arriving at her decision. So I think, again, it was really interesting that a large majority of you thought that maybe she hadn't made a well-informed decision. And I think part of that is because there's just simply a lack of information for us to make a reasonable judgment one way or the other on that particular element. So just a reminder, what are the other responses?
What was that? Sorry, Kat?
Oh, sorry. I just wanted to have a look at the other responses on the poll to this question. No, unfortunately, I can't see that. On the screen. So,
oh,
Anna,
sorry. So 20% said that they're concerned that she was not acting in good faith for a proper purpose. No one said that she had a material interest. 70% were concerned about whether she informed herself of the subject matter to a reasonable extent, and 10% were concerned that maybe she didn't rationally believe the decision was in the company's best interest.
Okay, I think that last one's an interesting one. And the reason that I'm saying that is, I mean, in paragraph 4 of the practical example there, it looks like there was a little bit of, at least some consideration given by Karen about Stephen's suggested course of action. She had regard to the goodwill and the company's reputation. And so those factors may have been playing on her mind. So I personally, based on the facts that we have, think that she probably has satisfied that last element. Norman, do you have a different view, or are we on the same page here?
Yeah, I'm on the same page. I guess what I just wanted to add, I suppose, that if you look at the duty in the first place, you would say that prima facie there may be a claim that she was negligent in not taking the CFO's advice. and really then assuming that she was in breach of her duty of due care and diligence in the first place by ignoring it, which is not necessarily a definitive answer, but let's assume that it was. You can see how then the defence can be called in to clarify that uncertainty, because as long as you can satisfy each of those elements, and as we said, particularly the Rich case, and Justice Austin explained that, it's a lower degree of standard when you're reviewing the actual actions, and a lot of emphasis is placed on whether it was made in good faith, proper purpose, and there's no material interest. And then it's just a question of process. If she went through a process, she clearly made considerations which were beyond her personal interest or the financial, the negative belief that costs had to be cut, and that would be the solution in the short term. She had a longer term view. She believed that the things would come out. So it shows that it does give you a bit of a soft landing if you happen to fall out of subsection 1 and prima facie have a breach of that. That's what I think, you know, is an important message at the end of the day in relation to that. Now, finally, I suppose we're a couple of minutes over time. I'm happy, and Karen, I assume you have a couple of minutes. If people want to ask any questions, you can so by putting your question up on the chat function. We might sort of see if people want to ask any further questions. There is one question up there, and it does say, is the view that directors should have shares in the corporation to ensure they are acting in the shareholders' interest, or should not hold shares, as this may make a potential conflict of interest argument? Now, I might just sort of have a quick go at that, and then Karen, you can sort of think about it and see if you want to add anything to it. It's an interesting question. I think in terms of what we're looking at today is really a question of saying the purpose of the business judgment rule and the section we're looking at is, you know, as we said, to expect directors to perform their duties with a certain degree of professional standard of care and diligence. And if they do that, and if they don't do that, that necessarily that they're not personally liable. There's certain factors that can be called to give them a defence in making a decision in an imperfect world. Whether they hold shares in the company or not, I don't think necessarily means that that they're discharging their professional standards. They have that standard no matter what, whether they have shares in the company or not. And having the shares in the company, again, doesn't necessarily mean that there's a conflict when they're exercising their powers. But as we saw with the Adler situation, you know, sometimes it can create an interest, and so did the Forrest argument. Although in the appeal of the Forrest decision, he was found not to have misled. And so, but the general principles that underlined that discussion didn't change.
Yeah, look, I agree, Norman. And I also think that particularly when we're looking at smaller companies, I mean, that's a very common scenario for directors to also be, you know, maybe the major shareholder. And on the face of that, that in and of itself doesn't create a conflict or mean that the directors aren't making decisions in the best interest of the company. But you are right. The problem becomes a little bit more prominent in corporations with substantial shareholders. Again, the prime example is the Adler case. So, yeah.
So, if there's no further questions, I might sort of just wrap up by saying, again, look, we're in very sort of challenging times, and there's a great need for directors to make decisions, and probably entrepreneurial decisions. There's other sections of the Corporations Act which we haven't really touched upon today, which deal with other areas where protections are given to directors in making decisions, particularly in insolvent trading. But the business judgment rule has its limitations, as we've discussed. But notwithstanding those limitations, over the next few months or perhaps year, decisions made by directors and officers will, in hindsight, be proven to have been made or with or without due care and diligence, and a need to examine that rule in greater detail will arise. If the courts follow the approach of Justice Austin in Richard's case, there is scope for directors and officers to find comfort in making those decisions and taking a balancing act between making entrepreneurial decisions with a bit of risk and the rewards that flow from that, and having some comfort in the defence of the business judgment rule. As we mentioned, there are limits. Those limits are that it only is a defence for the breach of the duty of care and diligence. It doesn't apply to all decisions made by directors, such as not complying with certain pieces of legislation because they think that's in the best interest of the company. And it's no benefit if directors neglect to make any decisions or neglect to perform their duty. So on the one hand, the law imposes a certain standard, yet on the other, there is another standard in reviewing the actual conduct, and that standard, I think, is there to support the ability for directors and companies to get out there and do things, notwithstanding the uncertain times. So, Karen, I don't know if you want to add anything in conclusion. No, you're muted.
Sorry. I just wanted to thank everyone again for, joining us for today, and hopefully you have some key takeaways that you can take away with you.
Yeah, and please don't hesitate if you do have any questions that come to you later or require any further information to contact Karen or myself. We'd be glad to provide you with any further information. So thanks once again. I hope everyone has a safe and restful Christmas, and we get there in one piece, and hopefully 2021 is going to be a much better year for everyone. So thanks once again, and we look forward to catching up with you soon.
Thank you. Thank you, everyone.